Ladies and gentlemen, welcome to the Georges River Local Planning Panel meeting. We are the panel who've been appointed by the Council to determine specified development applications, including development applications that are referred to us by the Council. But today we are here in the capacity of delegate of the Georges River Council for the purpose of deciding whether the planning proposal on the agenda should be forwarded to the Minister under section 3.34 of the Environmental Planning and Assessment Act. So we're performing a little different role today to what we normally do in relation to the determination of development applications or making recommendations on planning proposals. We're actually standing in the shoes of the Council to make a decision about forwarding this planning proposal on to the Minister, or whether to do that. My name's Adam Seaton and I chair the panel. The panel members that we have today are Michael Levy to my right, John Brockhoff to my immediate left, and our community representative Erin Sellers to my far left. I'm required to advise you that under the provisions of the Environmental Planning and Assessment Act, this meeting of the panel is being live streamed. There's a camera at the rear of the room and will be made available on Council's website. Everyone who comes forward to speak today needs to ensure that they speak into the microphone that's on the table clearly, and when speaking we ask that you ensure that your speech is respectful and appropriate. Any person who uses defamatory, discriminatory or offensive language may be exposed to liability for which Council and the panel take no responsibility. Any part of the meeting that is held in closed session is not recorded. The panel has received a report relating to the planning proposal, as well as the various attachments referred to in that report, which are voluminous. Under the code of conduct that the panel is bound by, panel members are required to disclose any conflicts of interest in respect of any matter on the agenda for a panel meeting. The relevant forms that are prescribed by the New South Wales Department of Planning have been completed and they have been tabled, and I table them here to include on the online minutes for this meeting. No panel member has disclosed any conflict of interest in the matter on today's agenda. In relation to the process of the meeting, only those persons who've registered to speak with the Council prior to the meeting will be permitted to address the panel. Each person will be provided 3 minutes to address the panel, but if you need a little longer and your points are relevant, we can give you some extra time to make sure we understand your submission. Those persons who are seeking to address the panel should come forward and sit at the front and sit at the front of the room here in one of the chairs and talk clearly into the microphone. And once we've heard from all of the people who've registered to speak, we'll then adjourn the meeting, deliberate on the matter and make a decision which will be published on Council's website tomorrow. So we're now going to proceed with hearing from the people who've registered to speak, and I have a list of 7 people who would like to speak today. At the moment, I think only 5 of those people have arrived. We'll see whether the others do turn up during the course of the meeting. I'm just going to go in the order of the list that I've been given. The first person on the list I have is Aaron Sutherland of Sutherland Associates Planning Pty Limited. And Mr. Sutherland, can I ask you to come forward?
Yes, I think Mr. Ryan as well.
Yes, I do have Mr. Ryan as well. You want to come together? That's fine. Yeah, for sure. There's no problem with that at all. Yeah. Gentlemen, if I could just ask you to introduce yourself formally and in what capacity you're here.
Yeah, absolutely. Thank you, Mr. Chair. My name's Aaron Sutherland. I'm a consultant town planner. I also have an ownership role in relation to this property.
I'm Chris Ryan. I have the ownership of the property as well.
And when you're speaking of the property, can you just describe the address of the property?
Sorry, 143A Stony Creek Road, Beverly Hills.
Thank you. All right, gentlemen, who wanted to speak first?
Mr. Chair, I'll speak first. I sent in a submission to the panel secretary, which I believe was distributed to you.
We have that document, yes.
Great, thank you. Because I just want to take you to some of those photographs in that, if I could. I've got spare copies if that's handy.
If you've got more,
copy.
We've all got them on our computer. Well,
Excellent.
thank you. Oops. Thanks, Mr. Sutherland.
Great, thank you. Mr. Chair, as Mr. Ryan's just mentioned, so the site's known as 143A Stony Creek Road, Beverly Hills. It's also quite well known as what's called the ex-RTA site in Beverly Hills. It's been used as a RTA administration centre for over 50 years and occupies approximately 480 square metres of floor space. The remainder of the site's occupied by a hard stand area for 40 cars. The site was sold by the New South Wales State Government in mid-2018, so nearly 2 years ago now, and it's historically functioned as an important service provider within the Beverly Hills local centre. It's approximately 500 metres from the Beverly Hills train station. Currently, the site is zoned SP2 Government Administration under the Hurstville LEP 2012. There are no height or FSR restrictions on the site. Over leaf, I've got some images of the site just to assist you with understanding the property. So figure 1's an aerial view, and it shows the administration building in the northeast corner of the site and the expansive hard stand which occupies effectively the majority of the remainder of the site. And then you have photograph 1, which is the corner of the site showing the building, and you'll see some graffiti on the building. I'll come to that in a moment. Photograph 2 on page 3 shows the southern side of the building and the entry into the car park. And then photograph 3 is essentially within the site, and you can see in the distance a three-storey residential flat building across Stony Creek Road. And then photograph 4 and 5 are interior photographs of the building. Everybody's been in a building like this in the past. So at the moment there's 17 counters within the building. There's backup office, so we estimate that there would have been employed with the site around about 20 people for the duration of 50 years. I achieved my licence there when I was 17, so I know the site quite well. The matter that you have before you this evening proposes to change the SP2 Government Administration Zone, and proposes to change it to an R2 low density residential zone, and where there's no height control at the moment, introduce a 9 metre height, and when there's no FSR control at the moment, introduce a 0.55 to 1 FSR. So as I mentioned, the building's been surplus to the New South Wales government's needs, or the RMS in particular. It was sold in 2018. It's been vacant since as a result of that zoning. The building, since we've taken ownership, has been vandalised and broken into on multiple occasions. The site's locked, but obviously it doesn't prevent people from jumping the fence, and that's the situation we've had, and we've had complaints from neighbours. The harmonisation LEP, we say, should probably enable the existing office building to continue to be used for a commercial basis. And in addition to that, the property right now has been charged rates on a business basis, not a residential basis. And what we're saying is that harmonisation should, by definition, reflect the existing circumstance. It shouldn't restrict us from being able to continue to use this building for a real estate office, a hairdresser, a restaurant, or something of this nature. However, the harmonisation LEP proposes to convert the subject site to R2 low density residential zone, which does not properly reflect the historical role that the site has performed in the last 50 years for the town centre. And as I just mentioned, it does not even allow us to use the existing building on the site for an ongoing commercial use. Furthermore, that use of R2 residential does not correlate with the council comment on page 68 of the report that employment floor space should be retained and enhanced to support local jobs for local people. So let me be clear, this change is reducing the employment opportunity that should be available on the subject site. For this reason, we're saying that the R2 low density doesn't properly achieve harmonisation outcome, and instead the most appropriate outcome is for the zone height and FSR, including a minimum non-residential FSR, to reflect that's in the town centre. This site has served as an important administrative function in the town centre for over 50 years and should be able to continue to do that. So therefore, we're seeking an amendment to the harmonisation LEP, and we say that the appropriate harmonisation is a reflection of what's in the town centre at the moment, which is the B2 local centre zone, a height of 15 metres, an FSR of 2 to 1, and a minimum non-residential FSR of 0.5 to 1. So they're the exact controls that you find within the town centre, which is King George's Road, and also several side streets which extend off King George's Road further to the north. These controls are also consistent with Council's local strategic planning statement in that they would allow the site to continue to be used for employment generating uses, and they also require a minimum employment use as part of any future redevelopment of the site. Put simply, we say that the R2 residential zone is not appropriate for this site. It's a large site, 2,500 square metres. R2 low density residential will require individual access to some in the order of 5 lots from Stony Creek Road, which won't be permissible under SEP infrastructure. So we're saying that that's not the correct zone. It should be a zone which reflects the town centre and allows that ongoing role. And also, as a minimum, allows that building to actually be used for a meaningful purpose, for employment purposes in the near term. Right, Chris, did you want to add anything?
No, I think you've articulated it pretty well, but I'm here if you want to discuss any issues associated with the site.
Okay. Gentlemen, are there any questions?
Just one question. You were saying the site had been sold by the RTA 2 years ago?
Yes, 8 months ago, correct.
Okay. And have you taken any steps towards a separate planning proposal?
Yes, we have. Yes. So, thank you for the question. We were looking at lodging our own planning proposal early last year. We had a meeting with Council in March. Council asked us not to lodge that planning proposal because they are undertaking Beverly Hills Town Centre review. We were informed in November last year by Council's strategic manager that this site has now been removed from that process and from that review, and therefore we've moved into this this process. It's for that reason we didn't address the panel last year, because we weren't aware of this change proposed through this process, because we had understood we were involved in the town centre process. As I said, we've since been informed that the site's no longer considered to be part of that process. If this is to move forward, we're in a situation where there's no further outcome that can be achieved at a later date through another process, other than us having to lodge our own planning proposal to reflect the request we're putting to you today. We respectfully suggest that this is the appropriate time to achieve or reflect controls that allow the building simply to be used for a commercial purpose, because of the fact that then there needs to be a transparent process. This needs to go on exhibition. It shouldn't come in later as an addendum. The public have a right to understand what's been suggested on this site, and that should probably form part of that exhibition process. It's a relatively easy modification, and what we're saying is that that is the correct harmonisation. Frankly, at the end of the day, with this control coming in, we'll be in the same situation we've been in for 18 months, where we literally cannot occupy that building for some kind of relatively benign commercial use.
All right. Gentlemen, the zoning of the land that immediately adjoins to the south, I suppose the southeast and the southwest and across Stony Creek Road, what is it?
So the zoning around to the south and the east is R2 low density residential. The zoning to the north across Stony Creek Road is
Seems a bit high density.
R3,
it's R3 medium density residential. Yeah, 12 metre height. I think a 1 to 1 FSR.
1.5.
It might be 1.5 to 1.
Yeah. All right.
But obviously we have a site here that has a large RCM. We'd like to occupy the site. We've held off lodging our own planning proposal. We had a very extensive report prepared by SJB in support of an uplift for the site. We've been asked not to do that. We have respected council's request and not done that. And then we found that we're no longer part of that process, and all of a sudden we have an R2 zone, which, as I said, the R2 is simply not an appropriate use of a large consolidated site that's historically served the town centre and has the capacity for employment to continue on the site. So, not that it's relevant to today, but we are now investigating an office development of the site. But certainly in the meantime, we'd also like to be able to use the asset as it is. There's been no income on the property for us for 18 months. We had a phone call from the neighbour 2 weeks ago asking if we can repaint the graffiti that's on the building.
Or get rid of the graffiti.
Yeah.
We'll get rid of it. That's
Repaint it.
He's asked to
repaint the building
for us.
All right, gentlemen.
Right.
No other questions?
No questions.
Good, thank you. If you'd like to take a seat, or you're free to go. As I indicated, our decision in relation to this planning proposal will be available tomorrow. Great, thank you. The next speaker is John Toddle.
afternoon.
How are you, Mr. Tolliver? If you can just, thank you.
Just explain what
If you just like to introduce yourself and
Yes.
where you're from, please.
Good afternoon, gentlemen. My name's John Totterdell. I live at number 4 Winder Street, Beverley Park, which is on the eastern side of the road, Winder Street.
And you'd like to say something in relation to the planning proposal?
Yes, I wish to object to items through 121 through to 126 and request their removal. The recommendations of these items, 121 through to 126, arose from the approval of a DA 2018/0516, which was from 5 to 11A Winder Street, and it was approved on the 12th of December 2019. And it suggested that, 1, the traffic report undertaken by the developer was flawed and inaccurate, and 2, the transition between the western side zoned R3 of Winder Street and the eastern side zoned R2 was completely inadequate. At the present time, in Winder Street and John Street, there are 5 high-rise DAs approved, 2 high-rise DAs pending. A massive increase in traffic is inevitable, and a thorough traffic study report should have been already carried out by the developers to allow council to properly assess these DAs. I strongly object to the rezoning of the eastern side of Winder Street and John Street to allow the appropriate transitions between the R3 and R2 zones. Setbacks and height limitations should be confined to the R3 zone to accomplish the necessary transitions. Rezoning of the eastern side of Winder Street and John Street to provide the transitions between the R2 and R3 zones would imply continual rezoning across Beverley Park and Congra Bay areas. The R2 zone area should not be rezoned to accommodate encroaching high-rise development. At this time, there is a draft DCP on public exhibition, and the question of building setbacks and height limitations to obtain suitable transitions should be addressed in the DCP, not the LEP. Furthermore, due to overwhelming objections over the development of the local government area, at a community strategic plan pop-up workshop in early March 2019, we were promised by council that the existing areas zoned R2 would stay R2. Thank you.
Mr. Tottle, are there any questions?
Just one observation, if I could, and being a panel member who was on the Winder Road application and being aware of what was said, just like to clarify, this planning proposal does not rezone that land. But one of the things that the panel asked was whether or not the R2 zone as it currently stands on the other side of the road is the best transition. Are there other options? What would the traffic implications be? So that's what was asked. This report is identifying that the panel had asked that and has said, look, that's something that will be considered, but certainly there's no proposal in here to rezone the land, just that it's something that will be looked at as part of the next stage of the LEP.
Well, my concern was originally when the LEP 2012 was amended by Cobra City Council, the land on the western side of Winder Street was not zoned R3, it was zoned R2. And it wasn't until after the public submission period closed that it was a rezoned R3. We went through a number of forums, a number of meetings with council, and we actually got height limitations of 9 metres rising to 15 metres with setbacks up to 12 metres facing Winder Street. Now what actually has happened, all that's gone. We lost that when it got gazetted and it reverted back to straight up 21 metres. So my concern, why I'm bringing this up today, is I want I would prefer to have that taken out so there's no option or no question about it coming up in the future. Because last time we thought we had setbacks, we thought we had height limitations, we thought there wasn't going to be any more rezoning. But now that just this, even the suggestion of it is sort of worries us considerably. So we prefer,
I understand what you're saying. That
if
you
the items
understand
weren't there,
Yeah.
there's no one, not that we don't trust everyone.
Yeah, we're just trying to understand what you were saying though, because this planning proposal isn't changing, well, it's changing the zoning from R3 to R4,
Yes,
but it's not changing the height controls or anything, but you're concerned about the comment that something may happen in the future to look at that.
yes.
Okay.
And I do believe that if you want transitions into from the R3 to R2, it should occur in the R3 zone. Like if the dividing line's in the middle of the road, well, it should be on the western side of the road. That's where the transition should take place.
Right. Thank you, Mr. Todd.
Thank you.
Councillor Payer. Thanks, Ms. Payer. If you'd like to just introduce yourself and tell us your submission, please.
Yes, Leisha Payer speaking as a resident of Cogra Bay. I must declare that I was elected in 2017 to serve Cogra Bay Ward, and I voted to prepare and later endorse the draft amendment to the Cogra DCP 2013 currently on exhibition. That Cogra DCP amendment is underway for both sides of the Princes Highway from Jubilee Avenue at Carlton to Park Road at Cogra Bay, which should have been part of the upzoning under the Cogra LEP changes conceived back in 2014 known as the New City Plan. The upzoning was made without strategic studies or traffic modelling to prove the increased business or residential capacity of either side of a congested national highway. Under the New City Plan, half of the unguided developments for this area have been initially refused. They have not addressed the traffic issues, the transitional zoning, nor the heritage items Sunnyside. The 12th of December 2019 Local Planning Panel meeting approved the DA for 5 to 11A Waiuna Street, Beverley Park, without a transitional setback to the R2 zoning throughout this area. The panel's approval included strategic comments that further upzoning could occur to the 60 or so houses comprising the blocks on the opposite sides of those streets. The panel then deferred 71 to 73 Jubilee Avenue, Carlton, which has been recommended for refusal. Those panel comments have been included as last-minute additions to the new LEP here, which I believe flies in the face of the stated objectives for preparing this new LEP with the community's involvement. Those inclusions could be used to inform the duplicate DA under assessment at 13 to 21 Waiuna Street, behind the heritage item Sunnyside, and the DA surrounding Sunnyside itself, which the panel refused last September, for which an appeal has now been lodged with the court. This draft LEP will also give rise to further speculative action on surrounding properties. LEP considerations are usually kept confidential to prevent this. The only ever neighbour notification for these two blocks was implemented in 2014 for the New City Plan as R3 zoning, which permitted a transition to the existing R2 zoning. This new LEP is further translating areas zoned R3 that are over 12 metres to high 4 high-density residential zoning, but R4 is providing for opportunities for greater activation. And this is to be located in walkable destinations for shopping and transport. This is not a location for R4. This submission is requesting the deletion of the new paragraphs of panel comments from 121 to 130, and also requesting the return to R3 or a limitation of an R4 proposal between the highway and John and Waiuna Streets, as no neighbour notification or community consultation has occurred. Contentious development should not inform the preparation of the Principal Georges River LEP. Thank you for your consideration.
Just so I'm clear, the paragraphs you're requesting be deleted are paragraphs in the report to the panel that we're dealing with tonight?
Yes, 121 to 130.
That's why I'm a little confused, because that is not the planning proposal. The planning proposal is the other document that is attached to the report, which doesn't have any comment in it about...
I'm agreeing with Mr. Totterdell that residents do not need this worry.
So I can't take those comments away. They're already out there in a report. So that's not something I can do, or nor can the panel do, but the planning proposal itself, which is the document that's attached, that document there, doesn't propose to do anything in relation to creating this transition zone. I think all this report was doing was addressing comments of another panel, saying why they're not doing what the panel suggested be done in relation to the planning proposal. So I think there may be a little bit cross purpose because the planning proposal isn't doing what those paragraphs you've referred to are saying.
Right, then,
So,
well,
yeah.
my submission is that the.
But I can understand the concern
R3
that
to
could
R4
happen in the future,
in that
if that's the
spot, yes.
concern.
Yeah.
Yes. Good. Thank you.
Thank you.
Mr. Cartwright is the next person on my list. Is he here? His name hadn't been ticked off, even though he listed. Mr. Graham Cartwright? No. Councillor Warren Tegg. Councillor, would you like to come forward?
Thank you, Chair.
Just give us your name and...
So, Councillor Warren Tegg, I'm here to suggest amendments to the underlying document, which I believe, which I lodged with my request to speak. So I'll be very brief. Those amendments were amendments I intended to move to the LEP had it been voted on in council, which, as you know, the reason we're here today is because it couldn't be. I am seeking those amendments to effectively do two things: to address the two major concerns that I have in my conversations with members of the public, which are, as you can imagine, voluminous when it comes to redevelopment, that when things are redeveloped, there is not enough green space. And so the changes that I'm seeking to make increase the green space requirements for some developments, which I think is an important aspect to address concerns that residents have, though the bulk of the amendments that I'm seeking to make to this LEP are to put in place a design guide principle, a design excellence principle, effectively to give the staff, who are the people making these determinations, the tools they need to improve the quality of the amenity, of the visual impact, of the relationship with the neighbourhood, of these new developments, to address those key concerns that are expressed to me, as I said, time and again, by residents in our community. So I think, in my view, these are good changes. I've worked with the staff on them and taken their advice as to the best way to implement this sort of urban design principles, and so I encourage you to adopt them and to implement them into the LEP.
Thank you, Councillor. Any questions?
No, could you just remind me again, and the group, what the outline of the particular changes you're after, Councillor?
So I can walk you through them. Effectively, the first of those changes is to add into the aims an additional subclause to add an aim to promote high standards of urban design and built form. So that is a key highlighted thing when people come to the Georges River in order to develop. But this is a thing that we expect in this community. The second amendment is to go through landscaped areas in environmental protection zones to increase the landscaped provisions within 3 of the clauses there, to increase them to 30% for houses, to 35% for dual occupancies, and so on. And then the third change is to add a range. The third change is to do with the landscaping and to just exclude swimming pools and hard paved areas. And then the fourth change is to just go through and set out for staff and for applicants what we mean when we say urban design principles. So it sets out a new clause 611 that just goes through and sets out what it is that we mean, how it will be interpreted, what we want to see. And so that's things like suitability, looking at the use mix, the density in its context, and a range of other design principles that we want to see in the area, so that when people bring plans to us, they know from the get-go what we expect, and it gives the staff the tools that when people put through developments that are just inappropriate and, to be frank, ugly, it gives them something to point at and say, the reason we're saying no is this, and we need you to come back with something that is more in keeping with the neighbourhood, that is not just, a cement wall on the boundary that goes to the box that's the exact right size to get your FSR, that we expect things to be appropriate and to look nice.
So you referred to environmental protection areas, that's foreshore building areas?
Yes.
And in relation to the design excellence provisions,
those are for the...
talking about, again, because I think they apply to development over a certain height or land within the foreshore protection areas?
I'm not able to answer that question.
Okay.
The
It was development generally you were referring to.
yes.
Councillor, I've read the clause that you're proposing, 6.11 urban design, and I'm just wondering how it adds anything to clause 6.10, which is the urban design, sorry, the design excellent provision, which actually refers to urban design. In it, it says the objective of this is the one that's in there at the moment.
Yep.
The objective of this clause is to deliver the highest standard of sustainable architecture and urban design. In 6.10, it then has identical requirements to your 6.11. So I'm not seeing how it's adding anything by putting a 6.11 that then wants to refer separately to urban design.
I'll
And and quite frankly, I don't understand the difference between architecture and urban design. They overlap
yes.
a lot. And particularly I've got a clause that is directing me to architecture and urban design already in the LEP, putting another clause in that has almost identical requirements. I'm not sure whether that's going to help much.
Well, in my conversations with staff, they were of the view that this clause.
I'm just, when you read it, it's identical in every other respect, other than using the word urban design in one part of it. But the requirements of it are identical. We'll look at it, but I'm just not sure whether it achieves anything more than what's in 6.10 at the moment. I understand the concern, though, wanting to marry urban design and architecture and making sure the outcome is an acceptable, in fact, an excellent outcome. That's what the words are that are used.
Yeah, and so if it is the view of the panel, I mean, each of the four clauses can be read separately or together. So the including the design excellence as an aim, I think, is a different and worthy goal. And if the view is that 611 doesn't achieve much more than the existing 610, I'd encourage the panel to consider adding the aim separately to the detail that we've decided to set out in 611. Joint and separate, I suppose.
Good, thank you.
One question. Have you considered at all the definitions used in the council report of landscaped area? You referred to the importance of changing and lifting the percentages of the landscaped area in the different zones in relation to forest protection and so on, but they refer to quite a complicated bespoke definition that council's presented. Have you given any thought to that definition?
In my conversation with fellow councillors on this point in particular, there was concern about the difference with the state government standards, and that if we departed too far from what are the existing standards for what is and isn't included as in a landscaped area, that we might end up in a situation where this LEP becomes irrelevant because developers just choose the state government standard rather than going through the LEP, which is using the standards that we set. And so the concern was that by varying too far from that, in this we've just excluded some additional things because we want more deep soil planting, but we also don't want to have to, what people worried about putting in pavers and stepstones to walk through gardens and things like that. So it is a difficult issue. One that I think we try to be flexible with, in my understanding. I appreciate the concern, but my understanding is that the further we vary our LEP from what the state government sets out, the less likely we are to have people using it, which is at the end of the day the goal.
Yeah, I'd put to you that the standard instrument definition of landscaped area is actually may well appear to require a greater degree of landscape quality, deep soil planting and the like than the definition that councillor put forward, and would appreciate your views on that.
I'm not an expert that I could dispute your experience view on that, but
Just to clarify on that question of 6.10 versus 6.11.
Yep.
Are you suggesting the urban design requirements should apply to all development in all zones, or is it the foreshore building areas and buildings of greater than 12 metres, which is what clause 6.10 covers at the moment? I'm just trying to see what that difference is further to what the chair was asking.
Yeah, so the second point under 611 here says that this clause applies to development not specified in clause 6.10.2. And so I get the.
So it's extending.
Yes.
Okay.
That is my understanding. Again, this is a very
That's what it is
complicated.
doing, Yeah.
Yeah.
So
So,
you want to apply to everything else?
yes.
Yeah.
Yes. That was certainly the intention. So if that's what my amendment has achieved, then I'm glad, because that's what I would like to see, that every bit of new building that takes place in the council area has at its heart design excellence.
Okay.
Any other questions?
No. Okay. Thank you.
Thank you.
The final speaker, David Hoy. Mr. Hoy, could you just give us your name and who you're representing?
Thank you, Mr. Chair and panellists. David Hoy, I'm a town planning consultant. I'm representing Centre Group, who are the co-owners and managers of Westfield Hurstville.
What would you like to say?
I'd like to just read out the following, if I may, please, and happy to answer any questions at the end. I've given you my details. I presented to this panel when the matter was first considered in October 2019, and that's been documented in the report before you today, paragraphs 118 to 120. Excuse me. However, and with all due respect to the panel, the report before you today, in my opinion, has fundamentally missed the point insofar as the immediate implications of this draft LEP and what it has in terms of delivering and significant planning risk on Centre Group's ability to continue to invest in Hurstville in the short to medium term. Put simply, the current zoning on the site permits residential apartment development. The draft LEP removes that ability. Excuse me. Similarly, there are currently no FSR or height controls in current LEP controls that apply over the site. They are contained in a DCP. The draft LEP seeks to impose those existing DCP controls that have been varied on numerous occasions since they were first adopted since they were first adopted nearly 20 years ago, and currently have no bearing on built form. Excuse me. The planning proposal that was originally presented to this panel last year was based upon a number of overarching principles, and these are again restated in today's report and include achieving equity across the LGA through the harmonisation process, particularly in respect to development potential, retain existing controls where the status quo can be maintained. In my view, the draft LEP provisions simply do not align with these principles. The draft LEP before you does not harmonise, and they do not retain the status quo as they apply to the Westfield site. The effect of the draft LEP is effectively the downzoning of the Westfield site from its most logical, best fit B4 mixed use zone to B3 commercial core. And on that point, just to remind the panel, the site's a deferred matter from the current LEP, and the 1994 Hurstville LEP provisions apply, where it applies a B3, 3B business zone. Council's own evidence base used to inform its planning proposal before you today includes an economic study prepared by Hill PDA on behalf of Council, which forms attachment 13 to the planning proposal, and it states, and I quote, "There remain numerous opportunities for expansion and densification in the strategic centre, including both east and west ends of the centre for mixed-use developments. There is also the option for redevelopment or partial stage redevelopment of Westfield to include residential towers above an expanded shopping centre. This cannot be achieved within the proposed B3 zone. The panel in its previous deliberations concluded that the B3 zone would not inhibit the proposed growth of Westfield Hurstville, such as the expansion of a rooftop terrace for additional dining. That may be so, however, any DA for such would need to rely on clause 4.6 of the LEP to vary controls if this LEP progressed through to gazettal in its current form. As a practising planner, there's a distinct aversion by planning authorities to start varying controls as soon as they are gazetted. This presents a significant risk to my client, and for example, a 1 metre increase in height above the currently proposed 19 metre height limit would necessitate a circa 115% variation to the height control, and similarly, a variation would also be required to the FSR control using clause 4.6. This plan proposal seeks to incorporate deferred lands, as I've talked about. Paragraph 139 of the report before you today clearly states that Council has adopted a best fit approach for translating zones in the LEP. I would contend that the B4 zone is the best fit for the 3B zone if the overarching draft LEP principles are to be consistently applied. Under section 3.82 to 4 of the Act, a planning proposal is required to give effect to any strategic plan, and Georges River is subject to the Southern District Plan. Planning priority S3 of the South District Plan states to provide housing choice, supply and affordability with access to jobs and services. Council's evidence base, quoted above and included in the report today, acknowledges the ability for Westfield Hurstville to contribute to that supply. Planning priority S9 of the South District Plan is to grow investment, business opportunities and jobs in strategic centres. For the reasons above, I believe that this places a significant risk to the draft LEP places a significant risk to the achievement of that insofar as Westfield's ability to align itself with the Southern District Plan priorities. If implemented in its current form, there is a risk that this LEP, as it relates to the Westfield site, cannot give effect to the South District Plan. Centre groups on the public record and remain strongly committed to supporting the long-term evolution and development of Hurstville Town Centre in a way that's broadly consistent with Council's long-term vision. It's recently reaffirmed this position in correspondence to Council, including a clear intent to engage in the subsequent LEP 2022 process. In the meantime, however, it's plainly clear that LEP 2020 results in a downzoning, which is contrary to Council's stated intent. It certainly does not result in harmonisation as otherwise envisaged by the proposal before you today. We request that the planning proposal be amended before it is placed on public exhibition, and again for the ability for a transparent public scrutiny of a draft LEP that applies at B4 mixed-use zone of the Westfield Hurstville site and applies built form controls that are generally reflective of what exists today on site, including a maximum FSR of 2.5 to 1 and a maximum height of 40 metres. Happy to answer any questions. Thank you.
Any questions?
Only if I could just confirm the deferral related to the Westfield site itself and the surrounding land was rezoned through the last LEP?
There were 3 sites that were deferred, the Westfield site and 2 other council-owned properties which are identified in the report before you tonight.
Okay, and what zoning did the land surrounding Westfield take on as part of that LEP, and what types of development standards were proposed?
If you turn to page 34 of the report before you, there's an extract of the current zoning map. The white block obviously being the deferred matter and being the Westfield site, and you'll see to the east is a commercial core B3 zone, and surrounding it to the west, north and south is also mixed use B4. So if you ask me what those controls are off the top of my head, I'm sorry, I've...
No, it's just saying, so the light purple is the B4 and the
Correct.
Blue is the B3.
Correct.
All right. No other questions?
Thank you.
Thank you, Mr. Wood. Ladies and gentlemen, that concludes the speakers in relation to the planning proposal that's on the agenda tonight. We're now going to adjourn this meeting and deliberate on the matter, and our decision in relation to whether or not the planning proposal should be forwarded to the Minister will be available tomorrow morning on the Council's website. Thank you for attending.